hearing of the evening, and this is the application of Edmund Saylor. Did I pronounce that right?
Yes, correct.
Great. Who resides at 39 Pine Grove Street in Milton. The application is dated August 26, 2019, and the applicant is seeking a variance pursuant to section 6C2 and 6D3, side yard and rear yard provisions of the bylaw. The sections require that accessory buildings, in this case a shed, cannot be erected within 8 feet of a rear or side lot line. And the building inspector here reviewed the property and in his inspection report finds that this shed is less than 8 feet from both the rear and the sidelines. The property's in a residency district. My name is John Leonard. I'm chairman of the Board of Appeals. With me this evening to my immediate left is board member Ted Daber. To my immediate right is board member Nicholas Gray. Rules of the board are such that we'll first hear from the applicant's counsel, and then we'll hear from people present who have questions of the applicant, wish to speak in support of the application, and anybody who wishes perhaps to speak in opposition to the application. We're tape recording the proceedings, so we'd ask that anyone, before they speak up nice and loud, tell us your name and address, so we'll have a clear and accurate record of the proceeding. I've summarized the advertisement, so we'll have its evidence up to the present point. The application by Mr. Saylor, it's dated August 19. I'm sorry, it's August 26, 2019. And we have a letter from Birch Emer, a code enforcement officer of the town of Milton, who indicates it's dated 8/5/2019. He indicates that the office received a complaint, and they inspected the property and found the shed was being built on the property at 39 Pine Grove. The structure is less than 8 feet from the side and rear property lines, and this, in Mr. Amer's view, constitutes a violation of the Milton bylaw. And he asks that the violation be abated, and that failure to comply will lead to further legal proceedings by the building inspector's office. And so shortly after the letter, Mr. Saylor filed this particular application, so for variances. So without further ado, Mr. Sheffield, you're representing the applicant. Just come up, make yourself comfortable. It's good to see you again, Mr. Saylor, please.
Thank you.
Delighted to hear from you, Mr. Sheffield.
Thank you. I'm Attorney Bob Sheffield. I have a residence and business office in Milton. My office is at 553 Adams Street in East Milton Square. This is an unusual situation. I would like to give the board a copy of the plot plan, and in yellow is the demarcation of 8 feet from the boundary line. And the shed itself is 10 by 12.
Where is it? It's not on the plot plan.
It is here. And the owner of the property tried to locate it in the most inconspicuous portion of the yard, which is right in the corner.
Sorry.
The person that objected has submitted a letter to the board, and it says, to the Milton Board of Appeals, as the residents of 35 Pine Grove Street, we would like to state for the record that we support the application of Ed and Adla Sella for a variance on the location of a garden shed less than 8 feet from the property line. The shed is a tasteful addition to the property. As the closest abutters, we have no issue with the structure's placement at this time. Thank you, and this is signed by Matthew Graydon and his mother, Kathleen Blythe. And I want to submit that to the board. Because of the unique shape of the land, in this case, the most feasible and most practical approach would be to locate it where it is located and where the Blights are satisfied with its presence and its location. And they, as per their letter, are supporting the application. If we took a 10 by 12 shed and tried to locate it anywhere else on the property, it would be right in the middle of the yard. And the sellers with their family of 4 would have virtually no yard, and they would have to choose between having the shed or a backyard. We think that in this particular case, variance is appropriate. The lot is 5,024 square feet, and the house is located on most of that property. The neighborhood is all 5,000 square lots. And it is a part of East Milton, which is a C zoning designation, and the lot is appropriate in size with all its surrounding lots. So it's not a very small lot, but it is kind of a long wall insofar as it is fit in there more as a triangle than as a rectangle. And I would request the board issue a variance in this case based on the shape of the property.
Let me ask you a few questions.
By all means.
Number one, on the picture here, which I'm not good at directions, but it's like a head-on picture.
Yes.
It really doesn't show the back of the shed. How far away from the two rear converging lot lines is the back of the shed?
It's about 4 or 5 feet. In fact, if you have
It's hard to say. It looks actually closer than that from this photograph.
if you have a rectangular back, and you have a
No,
10-foot
I mean
shed.
to the side. If you look,
It's about 2 feet to the side.
Oh, from the side.
From the
I'm
side.
sorry, I was thinking,
Which, at 35 Pine Grove Street, which she doesn't, after we spoke and she came over and looked at it and stuff, she wouldn't prefer to have it moved any closer because it would block her kitchen window. If it came out 8 feet, it would be right in front of her kitchen window, which is looking at the golf course. And that would basically block her kitchen window if you had to move forward.
do you know whether the Matthew Graydon or Catherine Blythe,
Yes, those are the 35, that's the next door neighbors.
were they the neighbors that complained
That's
about
the
this?
neighbors that originally complained about the
Yes.
shed being built there. And then, after the inspector came and they saw the property where would 8 feet be away from her yard. Because once we move 8 feet from her yard, because the triangle of the property would be basically right in front of her window. And she didn't like that, the shed being in front of her window, because that blocked her whole kitchen view. And she has a big kitchen window.
so after the town's rules were explained to her and she saw the implication of it, she wanted to withdraw her complaint and support the application.
Let me ask you some other questions. One of the ways that you could make this this proposed shed a little less ominous is to put a smaller shed there, couldn't you?
Yes, that's true.
So,
But even if you,
who built the shed?
It's done by a company in New Hampshire, Ferry Shed, Tom,
You're kidding me. Ferry sheds,
Ferry Shed.
okay. Did they explain to you the process for building and siting the shed? Did they tell you you needed a building permit to build the shed?
No,
Did they build the shed or did they bring it on a truck?
they brought it ready.
Was it all assembled or was it
No,
in pieces?
No, it was in pieces. That's how they transport it.
Okay.
And then they come and build it on the side, they put it together on the side.
Did they discuss with you whether the shed may not be in conformity with the zoning bylaw?
No.
Did you
I
sign
asked them if
did you
we
sign a
need-
contract
I
with
asked
these
them if we
people?
needed- No.
You didn't? You didn't sign a purchase order or something to buy the shed?
Well, yes, but it doesn't,
I'm very sorry. I should have noticed that.
it doesn't say anything about permits, and they said as long as it's under 200 feet, you do not need a permit for it.
Maybe Mr. Sheffield needs further services from you.
I believe in this.
You didn't go up to the building inspector's office and show them the plot plan or where you were going to site the shed?
Well, I did after they said you need the 8 feet.
After there was a
but
violation.
I did show them after. And then,
I think in this situation, due to the size of the land and the shape of the parcel, and with their new house and with their size of the family, that the shed is, number one, appropriate, and number two, is put in the least innocuous position that it
Well, as far as Mr. Saylor goes, I'm not sure about the other neighbors, but we'll see if somebody else is here. I don't
By all means.
know. The other thing that I know you considered, but you certainly didn't say anything about it, is the size of the building. This building has gone through substantial renovations by Mr. Saylor, and this
it's
is,
built brand new, basically.
yeah, it's a new house, it's 2 stories, it's a big house on a small lot, and maybe that makes the backyard a little more difficult to site a shed. But I'll leave that to my colleagues. Let's see.
I will give
The only
a
reason,
copy,
the basement, it's,
I will give a copy of the appraiser's sheets
Oh, great,
showing
thank you.
the old house and the,
Yes,
and the new house, and that the footprint was pretty much the same as the prior footprint. It goes a little bit higher, but as far as the backyard is concerned, it's,
Okay, you think it's pretty much the same? It's
Pretty
built
much
on the
the
same
same.
footprint?
right.
Mr. Gray, do you have any questions?
Not at the moment.
Mr. Deva?
Yeah, I have a few,
Please.
I guess. Ms. Blythe and Mr. Graydon, are they on lot 14? Is
Yes,
that-
they are.
Okay. Lot 14 is shown on the plan. Did you speak to or show the plans to any of the other neighbors?
Went to the neighbors and spoke to them that this hearing was coming up, and of course, they had received notice, and there did not appear to be any objection.
Okay, which neighbors did you go to? Can you give me the lot numbers? Were
I
you,
spoke to the neighbor here.
is that 16?
16. Basically, everybody on the front. The person
Across
next
the
to
street.
14, yep. Next to 14, two-thirds, that'd be 13.
Mm-hmm.
16 is the last lot, so there's nothing behind it. Spoke to 13, no, and nobody,
And across the street or not?
Yes.
Yeah, okay.
that's people that's actually looking at the house, that's staring at the house.
And what was their response?
Yeah, no, they didn't care. They're like, it doesn't bother us. Haven't even noticed that, there was an issue, it should be in there.
They didn't
also
sign- they
con-
didn't sign any petitions for you, did they?
I didn't do a petition. I should have maybe, but I didn't. They, you know.
They also commented that the shed looked professionally made and similar,
Well, it should be, it is a professional shed, and if you look at the advertisements, it's one of the more prominent shed companies.
yes, it is.
But they come into Massachusetts and come into Milton, and they drop sheds wherever they want. This is not the first incident we've had with these people.
Okay. But I'm saying that
And
the
I
structure
think
is
they take
consistent with the house.
I think they take
and the
advantage
building.
of people, to be frank about it, Mr. Sheffield.
Maybe.
And I think that anybody who's as prominent in the shed business as these folks
They should
know
know.
you can't drop a shed 1 foot or 2 feet off of a property line. And in the last hearing we had dealing with something like this, these people were like bandits in the night. I don't want to be cruel, but they came, they erected the shed as quickly as they could, and they headed to New Hampshire before anyone could know what's going on. And they leave the landowner with a piece of property that is, has a non-conforming shed.
Right.
And I think it's awful. I think it's awful. End of speech. Ted, do you have any other questions?
So, I mean, normally, if this is as much a question to you, probably more a question to you, and maybe to Mr. Prondak since he's here. But normally,
He wants counsel, too.
yeah, you know, when we're considering things like this, the structure hasn't been built yet, and the construction of the structure and its final, you know, product and everything is reviewed by the building department. Is that correct? And as it goes along.
If a
yeah.
building permit were needed, that would be the way it would go. But if you're doing something and a building permit is not needed, often the problem would come to light after it was already there.
Right, but here a building permit was needed, and the owner,
Maintained, yeah.
who has the responsibility for, we don't have the contract in front of us.
No.
Who has the responsibility for going to the building department? Is it the landowner or the,
Well,
the
the
shed
fact
manufacturer.
is, no building permit was needed for this. And the building department said, when they saw it, that there's no need for a building permit for a
right,
shed.
but you have to have dimensional, you may have to meet the
Yeah,
dimensional requirements.
That's true, that's true.
Mr. Prondak, did you want to comment on that?
Only, Joe Prondak, Building Commissioner, only to confirm that a shed under an accessory structure under 200 square feet in area does not require a building permit.
Okay,
Still has to comply with zoning, but does not require a permit.
Okay.
great.
All right. I think, I don't have any other questions.
Okay, do you have anything else you'd like to add, Mr.
No,
Mr.
sir.
Sheffield, excuse me, I have Mr. Prondak on my mind. That's a good thing, Joe. Is there anybody else here who has a question of the applicant or wishes to speak in support of this application for variance? Is there anybody present this evening who wishes to speak in opposition to this application for variance? Okay, there's no such person. Do you have anything else you'd like to add, Mr. Sheffield?
No, sir, I think
Okay.
that wraps up the application.
All
And
right. Any other questions, Mr. Daber or Mr. Gray?
No.
Okay.
Thank you.
We'll call to an end the evidence portion of the hearing and decide this application right here and now. Mr. Gray, do you want to be heard first?
Sure. I think this case would be a lot easier to decide if the request for a variance had come before the shed was deposited on the property. Obviously, this is very helpful, by the way, Mr. Sheffield. The lot is, one of the areas for allowing a dimensional variance is where the lot is of an unusual shape in the neighborhood. Certainly, in this context, this lot would fit, in my view, that requirement to have it's like a triangle sitting on top of a rectangle, for example. That's an unusual shape. So in the normal course of things, if the application for variance had come before the shed was deposited and we had exactly the same facts that we do, where the closest neighbor is abutting to it, has approved it. There's been some collection of other neighbors, but no one appearing at the hearing in opposition. We've routinely granted this type of variance a lot in the past. I'm a little bit troubled by the fact that the shed has appeared before the variance was issued. So I'd like to hear from, why I would tend to support an application like this when the process was followed sort of in the normal order. I'm curious to hear what you gentlemen have to say about, think about it before I make a final decision.
Mr. Dabo.
No, I agree with everything Nick has said. I think it would also be helpful if we had, a measurement of the distances, so we know exactly what's being granted and what the variance is in terms of the number, the feet from the back line and
That's an interesting point.
sideline.
Can we write a decision, for example, without a specific,
We have at least 3 feet. 3 feet here. We have 12 feet from the corner, and then 2 feet from size 14 lot.
usually when we write a decision for a dimensional variance, we have a plot plan that shows exactly the structure and where it's laid out and the measurements that are on it, so that we can tie our decision exactly to that plan, so that you have something to record at the Registry of Deeds that shows exactly where you're entitled to position your shed. In your case, we have some verbal statements about where the shed is going to be located, some lines, but now if we're trying to write a decision based on, okay, you can park your shed, you need 8 feet, but you can park it, 2 feet or 3 feet or 4 feet. It's not clear to me how that decision would get written in the specificity that I think you would need to be able to have a firm grasp of exactly where you're entitled to position your shed. That's a concern, but again, I'm willing to listen to what you guys have to say.
I think it could be written insofar as the shed has already been located. It did not need a building permit, as the building commissioner indicated. It should have met the setback requirements. However, the landowner at the time was not aware of these setback requirements, and
I'm not sure I heard that, Mr. Sheffield, but I understand what you're trying to suggest. Mr. Saylor's been before the board several times regarding this particular property.
yes,
And I think he knows what the building, what the zoning law requires under various circumstances. Or he at least should be charged with asking intelligent questions before he goes forward.
if the board would like, I would,
The other thing I just want to follow up on, excuse me, I don't mean to interrupt you, but on what Nick was saying, in almost every variance application that we grant, we always grant it based upon a plot plan. There's no plot plan here. There's a drawing,
no, that's a signed plot plan.
but it doesn't show anything. And we're in the position here of, I don't want to put Mr. Saylor to undue expense, but it's part of the application that he never filed. And if we had that, it would at least allow us to draw an opinion, possibly granting a variance. So I think that that's not being overly technical on Mr. Gray's behalf. And it just infuriates me that builders can do something like this and tell me they didn't know that this was in gross violation of the bylaw. Have you written to these people and
No, we have not.
put them on notice?
No, we
They
have
should
not.
be sued, and they should pay your fees, and the anxiety for Mr. Saylor here in having to go through this. My problem with this entire application is I think we create a terrible precedent. I know Mr. Saylor has done a terrific job on the house, and it's hard work, and you've made some decisions on other hearings regarding the construction of the house to try to obviate the concerns of neighbors, and for that, we thank you. But I just think it's a terrible precedent to allow builders to get away with this and then have, I won't say innocent people, but certainly people who didn't participate in this, who hired a professional, who should have known there were dimensional requirements and didn't pay the slightest bit of attention to it, that somehow we should be granting variances. I think if this was ever appealed to the Supreme Judicial Court, they would think we're crazy. They would think we've lost our mind in granting a variance that's 2 feet off the lot lines and 3 feet on the other side. Just, it's all very, very disappointing, it really is.
I have no question, I agree with you that.
And I guess the other part of it is, what do we say to everybody else out in Milton who hires this particular shed company or some other shed company, and they just slap a shed up, and then they think, well, we have to give them a variance because we gave Mr. Saylor a variance.
Well, I think this.
The other remedy is to say no, and to allow you to sue this company for damages, and then build some type of a smaller shed that is in compliance with the bylaw. And I know that's, you're not anxious to do that. It's expensive, and that's my thought.
The difficulty that's unlike most rectangular lots is that this particular lot on this particular residency district would not have a good alternative location had he even known what the rule was here that he was violating. And most of the time, you do have an alternative location that would be.
Well, you've got alternative locations, they're just not in as convenient a spot for the landowner to enjoy his backyard. Another alternative is to do a smaller shed, but.
Both the landowner and the landowner's neighbors. This is the most innocuous location that could be conceived.
Anything else you want to say?
No, I was listening to it, and I had also considered the.
I think somebody, maybe in the building inspector's office, should consider talking to the Attorney General's office about this company. Maybe they have complaints already. My guess is if they do this in Milton on 2 instances that I know of, then they probably do it 50 times in Massachusetts, and then run to the White Mountains, and then grab the money, run for the White Mountains, and leave the parties to fuss with local officials.
They're not the only company that does this.
It's shameful. Okay, my view of this application, I do feel sympathy for Mr. Saylor. I think he probably should have gone to the building inspector's office in the first instance, but you hired a professional company and you relied on them to your detriment. It's obvious. But I think, well, I guess I'd be inclined to grant this variance. I think we kind of look crazy doing it. But I do realize that nobody else objects to it, and you're in a tough position here, and I don't want to foist a lawsuit on you and having you spend thousands and thousands of dollars on, it may be worth more than the shed. I don't care what you paid for the shed. Mr. Prunder, go ahead.
If I could make a suggestion, if you did choose to grant the variance, perhaps you could say the shed shall be 2 feet from the lot line, and then we could verify that later by an as-built plot plan. Just trying to be helpful, if that would.
No
Well,
closer.
but the problem is, if Mr. Saylor here makes a mistake in his dimensions, and that's what we put in a decision, and then the plot plan comes in and it's not, I'd rather do it the opposite way. I think Mr. Gray's suggestion is a good one. I don't think it's a very expensive project to get a plot plan showing the exact dimensions of the shed and incorporate that in our decision, and then there's no question that you're in conformity with the variance, and you're not going to have some other neighbor move in and say, how can that be there?
Or a buyer, if you end up selling the property at some point in the
But I
future.
definitely have more than 2 feet this way and more than 3
Okay.
feet the other way, so if they had to come and measure it, it's gonna be more than 2 feet, so if,
Okay.
if we did 2 feet, we know we're more than 2 feet.
Mr. Neighbor, what do you say to that?
No, I would agree. You mean continue this and get a
Continue
plot
this and
plan?
get a plot plan and,
That's what I was gonna
It's the safe-
suggest, actually.
It really is the
That's
safer
what I was-
approach,
Yeah,
I think. I mean, I hate to, I mean, I know that
right.
you've already invested a bunch of time in it, but that's,
and we can put in the decision that this is awful and this company is terrible and whatever. This is a unique circumstance and all of that. But we know it's not a unique circumstance. Where these Milton residents are being preyed on by these people, and it's terrible. How long do you think it would take you to get a plot plan, Mr. Sheffield? Couple of
21
weeks?
days,
I'm sorry?
21 days.
21 days, okay. What do we have going on a month from now?
We have a hearing on 12/5.
I like it.
which is waiting for a third case, isn't that right? Is that what
On
you were
when?
gonna say?
Well, December 5th, we've got a hearing scheduled.
December 5th,
Yeah, and
that'd be fine.
what we would do, like 7:15 or something like that.
That would be fine.
And it would really be just to get, and if you have the plot plan, send it in ahead of time, and then we can vote on the application. We won't take, the hearing's closed, we're not gonna take any additional evidence.
We wouldn't need to.
Then we can vote the decision and incorporate the plot plan into the decision. Then you record that in the registry of deeds and you're all set,
Excellent.
okay?
That would be fine.
Thank you for your patience, Mr. Sheffield, I didn't mean to
I think
Thank you,
tee
Jim.
you off on shed builders, but
there's
it's,
a possible conflict, but I'll work on it. I'll
On the
get it.
5th?
I think, yeah, but I think I can move it.
okay.
So-
Okay, so we're gonna be continued to December 5th, and we're gonna say 7:15. Is that better for you, Ted, or is it better to have it late?
No,
I mean, we could do 8 o'clock or
if,
something.
I mean, if I move the other thing, it doesn't matter.
Okay, well,
So
just 7
let's-
o'clock or 6:45 or something
no,
like that?
7
Give you
no.
This is a 15-minute, Hearing.
7:15 is okay,
okay,
yeah, thanks.
okay. December 5th, 7:15, and just file the plot plan as quickly as you can, and
We'll take care of that.
thanks for coming.
Thank you.
Sorry for your problems.
Thank you.
Can I steal the name off that?
Oh, of course. Yep.
What's the name of the company that did the shedding?
Reed's Ferry
Reed's
Sheds.
Ferry Sheds.
Reed's Ferry?
Reed's-
Yeah,
They advertise a
REED.
lot, and they
WBZ. Not follow particle board. See, I've been paying attention.
What's their jingle?
I forget the
Please
jingle,
don't
I'm not
burst-
going that far.
Don't burst into
It's
song.
all right.
That'll be a little too much. Bev, you want to grab that?
Put this right in the file there. Thank you.
Absolutely.
Thanks, Mr. Sheffield.
Thank you.
Thank you very much.
Bye-bye.
All right, this is, hold on, this is 70, about 7.
You all set, Mr. Johanning?
Absolutely.
Okay, Ted, are you?
Yes.
And
Yep.
Mr. Nick?
Yes,
are
Mr.
you-
Nick.
Okay, we're going to, oh, great, we have something, are these additional,
No, it's just,
oh, okay, these are these.
this is the email,
Email
yeah.
chain, okay,
If you want to,
Yep. Thank you very much.
okay, great.
okay,
I have to do some ceremonial
Sure,
things
sure.
first, Mr. Johann. Okay, this is the application of Philip Joe Henning. It's dated September 10th, 2019. And basically, it's an appeal of a decision of the Milton Building Commissioner that the special permit that was issued to, I'll call it their nursery without naming all of the other principals, by the Milton Planning Board on July 15, 2016, had expired, and that therefore the new special permit, which was subsequently issued by the planning board, is invalid. I think that's the best way to put it. The ad is long and it's complex, but that's essentially deals with whether the special permit was extended as a matter of law or whether it expired. The building inspector, upon a request by Mr. Joe Henning to issue a cease and desist order to Thayer Nursery, declined to do so, saying, finding that in the building inspector's opinion, the special permit had been extended by the filing of an application to extend the special permit before it had expired, and that thereafter hearings took place and an amended special permit was then issued by the planning board. So that's essentially the issue that's before us. We have as documents here for this particular hearing the application, which is dated 9/10/2019. We do have 2 pages of a series of exchanges by and between Mr. Joe Henning and the building inspector, and maybe been 1 or 2 other town officials that are involved. We have a application, strike it, it's a petition for renewal of the special permit that was filed with the planning board by Mrs. McGettrick. It's on May 15th, 2019. And we have a series of minutes of the Board of Selectmen, strike it, the planning board, which includes the latest minutes where they purported to amend and extend the special permit. So we'll have all of those documents as evidence before us here. So without further ado, let me just do the rest of it so we'll be consistent with the other hearings. My name is John Leonard. I'm Chairman of the Board of Appeals. With me to my immediate left is Board Member Ted Daber, and to my immediate right is Board Member Nick Gray. The rules of the board are such, as we previously explained. We'll hear from the applicant. We'll hear from people speaking in support of the application. We'll hear from people speaking in opposition to the application. I note Mr. Prondak, our building commissioner, is here. He may want to be heard. We're tape recording the proceedings as always, so that would ask that anyone who's going to speak, tell us your name and address, speak up nice and clear and loud, so we'll have an accurate transcription of the hearing. So without further ado, Mr. Joe Henning, welcome to the Board of Appeals.
Thank you.
Delighted to hear from you, sir.
my name is Phil Joe Henning. I live at 23 Parkwood Drive. I'm a direct abutter to Thayer Nursery. If you want to go quickly through the correspondence with Mr. Prondak, on August the 9th, I wrote him a note saying that the 2016 special permit had expired on 15 July, and that without a special permit, the landscaping business use could not be pursued on the property. It's not, if you look at the bylaw, a bylaw amendment, Section 3, subsection N, it doesn't say anything about applying. It says that it has to be issued. And this is a matter of the bylaw itself. We're not talking about anything but what is the wording of the bylaw, and is the building commissioner's decision consistent with the wording of the bylaw. The bylaw gives conditions under which the nursery can operate, can, let's say, legally operate. If you don't have a special permit, you don't know what the conditions are. And Mr. Prondak could not presume that an extension or a new special permit would be issued. He didn't know. So I asked him to issue a cease and desist order on August the 9th. I had given him, I think, 3 weeks to take some action consistent with the bylaw, and he hadn't done anything. So then, on August the 27th, I asked him again, is it your intention to respond to my email? Then finally, on August the 28th, he says, the renewal process is underway, application has been filed. I decline to issue the requested cease and desist order. I think that this represents, an exercise of authority well beyond the authority he has been given. The town meeting passed the bylaw amendment. It is very specifically worded. It does not give him the authority to allow a landscaping business to operate without a special permit. It doesn't say anywhere in the bylaw amendment that he has that authority. And so what we're talking about is how could he make a decision like this when a special permit did not exist at the time? And I'll state again that it is totally irrelevant that an application had been filed, because no one knew whether the special permit would be issued or not. No one knew what the conditions of the special permit would be. And so to suggest that the special permit would just be a mirror image of the special permit that already had expired would be outrageous. And so then, I think this is incredibly insolent, but Mr. Prondak says, as you know, you have the right to appeal my decision to the ZBA. That, to me, is incredibly insolent. He doesn't go back to the bylaw amendment and say what in the bylaw amendment permits him to do this. He just says, well, you know what? Go take me to the ZBA. I said to him, there is no special permit in effect at this moment. Under our zoning bylaws and under the decision of Norfolk County Superior Court in 2013 and 2014, there has no rights currently to operate a landscaping business on that property. You are not enforcing the bylaws of the town. The filing of the application is not a special permit. So what I'm asking for is for this board to agree or disagree with such an outrageous, assumption of authority where none could be supported by the bylaw.
Have you completed your presentation?
Yes, I have.
Okay, great. Do you have any questions of Mr. Johanning? Mr. Gray?
My initial question is, when has a special permit has been granted?
Yes, and I've appealed it.
Okay, and the date of this, well, we'll hear probably from Mrs. McKettrick in a moment. But doesn't the granting of the special permit sort of moot the issue for you?
No, it does not.
Why is that?
It doesn't, because at that moment, I asked him for a cease and desist order, and I had every right to do it. and it was consistent with the bylaw. And he refused to do it. And I'm asking the board, do you support that? At that moment, it doesn't matter what happened after. After, they could resume operation, presumably. I have appealed because I believe that there was not strict compliance with the special permit in many, many areas. There wasn't strict compliance with the parking plan, with the lighting plan, with the fence. The fence was specified with the landscaping plan. I demonstrated at the hearings that there were significant departures from what was required. I talked about during the public meeting that 5 dump trucks were required to be lined with a specific type of rubber. And he admitted here, Mr. Prondak admitted here, that only 2. Mr. Prondak was required to show that there was substantial compliance with the requirements of the special permit when he issued the occupancy permit, and he hadn't done that. So on top of the fact that Thayer had not complied, Mr. Prondak had not enforced.
All right. So I
well,
don't mean.
let me finish.
All right, I'm sorry. I was trying to,
So what I tried to
Yeah,
do
to what
during
we're-
the hearing
to what we're-
was to show that there had not been strict compliance, which is required. And the last time we had a hearing here, Mr. Leonard asked me where in the special permit was strict compliance required, and I pointed out the areas. And so strict compliance was the standard, and strict compliance had not been observed. So I took the time and trouble to show where strict compliance had not occurred, hoping that the planning board would see my point of view and tighten restrictions on Thayer Nursery.
I would only say,
But
this is not the, we're not here to appeal the planning board decision. So
I'm trying to
I-
get to the
yeah,
point. And the
Limit it to
point,
the specific thing that's on
the
tonight would be
point
helpful.
that I'm trying to make is you're saying it's a moot point because the special permit has been issued. And I'm saying I have appealed because I have made certain arguments and I felt that the town was not hearing them. So what I'm saying is he didn't have a special permit at that time. I was making a legitimate request under Section 3, subsection N, and it didn't happen. And I'm asking simply, I'm not asking for any other remedy except for you to agree that I had the right to ask and that he had the duty to respond to my request in a positive manner. He had the duty to issue a cease and desist order. The Zoning Board of Appeals in 2013 agreed with John Rowe and I, and they issued a cease and desist order that Thayer had to remove landscaping activities from the property. In response to that, Thayer brought the Thayer amendment to the town meeting, and it was passed. But it was passed with these words, and these are the law of the town. And so I'm saying, does Mr. Prondak have the right to assume the authority of town meeting and make changes that, he doesn't have the right to make in these? And what it gets down to is the protection of my civil rights as a citizen of the town. The bylaw is there and exists to protect my rights as a property owner. My property use is strictly in compliance with the guidelines of the zoning for an A zone. Thayer is not, but for the special permit. They did not have a special permit at that moment.
Okay.
Mr. Daybird, do you have any questions?
No questions at the moment. Thank you.
Okay, great.
No.
Thank you, Mr. Johanning. Is there anybody present this evening who wants to speak in support of Mr. Johanning's application, I guess is the best way to put it? And the record indicates there's no such person present. Mr. Prondak, you're here, Would you like to be heard?
I would.
Okay, thank you.
Joe Prondak, Building Commissioner. Thayer Nursery applied for the renewal of the special permit on May 15th. I understand Mr. Johanning's position completely. However, I disagree with it, and I do believe that I have the authority to make some reasonable judgments under any zoning situation that is not clear or well-defined in the law. Maybe to speed this up, let me put it this way. Had Thayer Nursery applied for a renewal of their special permit on July 14th, I certainly would have honored Mr. Johanning's request. But they applied for on May 15th, and I believe there were at least 2 hearings held on this particular matter prior to the expiration date. When someone is granted a special permit and they comply with the terms of the special permit and then apply for renewal and expect some sort of reasonably timed, speedy renewal of that permit, then I think it would be unfair, extremely unfair, to say, okay, because the hearings took so long, your permit has expired, and therefore you have to cease operations. I think this is true industry-wide. I've been enforcing and interpreting zoning for 33 years. I think that we all know that a zoning bylaw or a mass general law cannot cover every single situation. I think that Thayer Nursery acted in good faith in applying for the special permit early so that there would be time to hash out some of whatever had to be hashed out. So that was the basis for my decision. I think it was correct, and as I said, had Thayer not applied in a timely manner, I certainly would have issued a cease and desist order upon the expiration of that permit. And I would just like to briefly object to Mr. Johanning's statements that I have failed in some way to enforce the bylaw, to enforce the provisions of the special permit, and in fact, some of the things that he brought up were appealed to this board and decided and should not be part of the testimony.
Okay. Could I just have one question for you,
Yes, sir.
Mr. Prondak? And that question is, will you agree with me that the question of whether the filing of the May 15th application for renewal of special permit by Thayer Nursery and the effect of that filing is really a question of law under Massachusetts law?
I know of no law that addresses it directly as it's requested to be in this case.
Okay. You're not town council?
Right.
Okay.
I do know, for example, oftentimes this board will issue a permit with certain deadlines or dates, and that we routinely, should they go in front of another board like the Conservation Commission, that delays the implementation of a particular date, that those dates are often stayed. That's a matter of routine. Like I say, I think I acted in accordance with, let's call it industry standard. I think this is done quite
Okay.
frequently.
Mr. Gray, do you have any questions, Mr. Prondak?
No, I don't think
No.
so.
Mr. Deba?
No, sir.
Okay, I don't have any further questions. Thank you, Mr. Prondak. We appreciate you coming.
Thank you.
Mrs. McKettrick, I note your presence. Do you wish to be heard? I'm shocked. Good. Welcome to the Board of Appeals.
Thank you. I'm Mary McKettrick, and I did represent Thayer Nursery in their permit renewal application process, which began with their application being filed on May 15th, 2019, which we judged to be 2 months to be a reasonable amount of time ahead of the permit expiration to file the permit. In fact, the original permit, the application was filed on May 19th, and the decision was on July 15th. But, you know, the planning board is busy, and the planning board is generous. Nevertheless, the planning board is generous with its time, and if someone comes to speak before the planning board, the board allows them to speak. So we had a number of nights of hearings. Mr. Johanning was at all of them, I believe, and he had the opportunity to speak at each of them. It took 6 meetings, 6 separate meetings, to reach the end of the process of the public hearing. And then I think it was on, I don't have my paperwork in front of me, but I believe it's September 8th that the planning board issued a renewal, a written decision for renewal of the special permit. And I want to point out also that there was some delay in filing the written decision because town council assisted with the writing and was away for several weeks in August.
I have
So
it
there-
I have
there-
it being recorded September 13th.
I'm sorry, September 13th, okay.
2019.
So there are a number of reasons why it can take quite a while to get through a public hearing process. I did look for cases exactly on this issue, because I think it's an interesting question. And I didn't find cases exactly on this issue. What I did find were a number of cases. A lot of them, some of them most recently are telecommunications bylaws, just so happens. Because those bylaws come up, those facilities come up for renewal, and there have been all kinds of legal issues relating to whether they should be renewed or not. And one of the issues is what happens when an applicant who holds such a permit, or a company that holds such a permit, fails to file the application for renewal before the expiration date. That's what the cases are about. So I didn't find cases where the application was filed before the renewal date and an issue came up and there was litigation and there's an appellate decision. Maybe there is one, I haven't found one so far. But the fact that the cases are all about people who didn't file in time tells me that that's where the problems occur, and that the procedure, once you've filed your application, is that the process has to take place. There's actually a pretty long time period during which a permit granting authority has to grant a special permit. I mean, it's really long. It's 90 days after the end of the public hearing. That didn't happen here, thank goodness. So here are the general principles that I think actually apply here and that you should think about. One is just a general principle of equity that says the applicant should be protected from an order to cease operation in this situation when the time required for the hearing, and when he's filed his application timely, reasonable time before the expiration date, and when he is not, when the time for the hearing and the decision is not within his control. The second question is the one Mr. Gray brought up, which is that I believe this question is moot because the permit was renewed and the effective date is July 15th, 2019. So the renewal reached back to the expiration date. The permit wasn't renewed beginning on September 13th, so the applicant didn't get an extra month and a half of operation in some kind of limbo. You know, instead, in this case, in any case, I think the issue is moot because the permit was renewed and it did reach back to July 15th. And then finally, in general, on these issues of procedure before the board, the building commissioner and the Board of Appeals and Planning Board, there are due process questions. And if there's a violation under a permit, the applicant, the person who has the permit is entitled to notice that there's a violation. They're entitled to a reasonable time to cure the defect. So in this case, you know, the applicant's already taken the steps that he can to cure the defect. He filed the application. They filed the application 2 months ahead of the expiration date. What more could they do? I mean, are they supposed to file it a year ahead of time? So I feel that, you know, based on those principles of equity, the fact that it's a moot question at this point, and that there is due process, there should be due process afforded to the applicant, that it doesn't make sense that the building commissioner should issue a cease and desist order while the hearing is going on and before he knows the result. It would, once the hearing was concluded, if the planning board refused to renew, it's very clear that that's the end of the right to operate, and that at that point, there would have to be a cease operations. Section 3N allows the renewal to be granted, but in this particular bylaw, it doesn't happen to specify an amount of time before the expiration date within which an application must be made as well. So in some of the telecommunications bylaws that were subject to these other cases, there was a time limit. They had to apply a month ahead or 2 months ahead. And in some of those cases, the issue was, well, if they didn't meet that time limit, did they lose the opportunity? The results varied depending on some factors in each case. But it was very clear that the issue in all those cases was that the person who had the permit failed to apply before the permit expired. So those are my comments.
Oh, great. Now, don't run away. We may have a question for you. Mr. Gray, do you have any questions of Mrs. McKettrick?
No, not at the
Mr.
moment.
Dable?
I don't hear.
Okay, thank you, Mary. Appreciate you coming. Is there anybody else here who'd like to be heard? Yes. Why don't you
Hi.
introduce yourself, please?
I'm Maggie Oldfield. I reside at 397 Hillside Street.
Good. Welcome to the Board of Appeals.
Thanks. And obviously, I'm not a lawyer, and I don't have case studies as Mrs. McGettrick has.
That can be a good thing, you know.
I think it is because I really think I'm a much more practical and common sense person, and I believe in common sense practices. So basically, I just want to look at past practices of the town, and I think past practices should serve as precedent. So just quickly, recently, about a year or two ago, the permit of Eagle Farm expired, totally expired. He didn't even have his renewal application submitted. Totally expired. He was not issued a cease and desist by the town of Milton. And in fact, the town of Milton actually hired him to do snow removal in the period that he didn't even have a permit.
That's a nursery permit, is that right?
I'm not sure what his permit is, but it's just.
He didn't get a permit for plowing snow. So it was that's a little twist.
Yeah, so his permit expired. It wasn't renewed. He was able to operate, and the town hired him. And in the meantime, this board renewed his application, I think, in one sitting. It didn't go on and on and on for months and months. And he actually didn't even need to hire an attorney. He was able to present his case by himself.
Mr. Sanatellis can be a compelling witness.
So that's all my point is. I'm a huge believer in equality. I'm a huge believer in past practices of this town. And you just stated at the earlier meeting that you were afraid of setting bad precedents, because precedence is important, and I just would like it to be applied in this situation
Okay,
as well.
great. Thank you. Appreciate you coming. Anybody else like to be heard with respect to this application, either for or against? Mr. Johanning?
Again, I just want to say that I'm not asking for anything but for the board to agree or disagree with Mr. Prondak's decision on that date.
Right, we understand.
There may have been some retroactive decision, but on that date, that decision hadn't been made. And so it's interesting that we discuss equity. And equity is always for one party. It's never for both. There's another party here, and I think about equity for me and for my family and for my property. And I think equity needs to go both ways. With respect to the application date, they could apply at any time, and they knew that it took almost a year the first time around. So if you know that it took a year the first time around because there was tremendous controversy, would you think that 60 days was sufficient? We're
No.
talking about a year.
Not with the planning board.
Yeah.
It'd take a long time with
So-
dealing with many intricate issues.
So when we talk about equity, think about me as well as Thayer Nursery. When we talk about timeliness, think about a year versus 60 days. When we think about whether Mr. Prondak has these rights, we have to read what is actually in the bylaw. And the bylaw states that the special permit is required. The bylaw itself. It doesn't say an application is required. It says the special permit is required. So, I guess I don't get it. If he sits here and says that, he does have the authority because there's gray area, in my reading, there is no gray area. You either have it or you don't. And with respect to telecommunications companies and things like that, I don't think we're talking about apples and apples. I think we're talking about apples and oranges. So that's all I have
Okay,
to say.
thank you. Anybody else wish to be heard? And if not, we'll close this hearing and discuss it and vote on this particular application. Mr. David, you want to go first?
Sure. I also tried to research this issue and was not successful in finding any cases that were
Shocking.
exactly on point. Well, I'll be interested. Oh, okay.
Okay, so somebody found case.
Well, maybe you should go first then.
No, you go ahead.
I found a case that I think Attorney McKettrick was referring to in terms of the telecommunications. But in any event, what strikes me, again, is, that the special permit talks about it being renewable for, what does it say? Renewable for one or more additional terms of 5 years, and then it goes on. What strikes me is you really don't know how long the renewal process is going to take. You don't know what objections are going to be made or what issues are going to come up, who's on vacation, or who might get sick, how many hearings there are going to be. In this case, there were 6 of them. I think in that case, you can't, or at least I can't, unless Attorney Leonard here has something to dissuade me, say that you have to have the entire process necessarily completed by the end of the initial term, because, who's to guess how much time exactly you need? So I tend to think in this case that filing the application 2 months ahead of time, the fact that the renewal didn't issue until after the July 14th, I think it was, deadline, I think the renewal is still good, and I would tend to, favor that the renewal was good and that the special permit was properly renewed.
Okay, Mr. Gray.
Thank you, Mr. Leonard. Are we being asked to rule on whether the special permit renewal of it was good or not?
Maybe I'm phrasing that
no,
wrong.
I
Maybe,
just
I
wanna-
guess,
Yeah.
and that no, I guess I should be saying that no enforcement or cease and desist
Yeah.
order should have issued, is what I should say.
That's exactly.
Yeah,
That's what I
I
should
just want
be
to make sure,
saying. Yes.
because the way I'm hearing it is that in the terms of the appeal that Mr. Johanning filed, he's appealing the decision of Mr. Prondak.
Correct.
For not issuing a cease and desist order after he was given notice in August, I think.
Yeah, you're right.
August, I wrote my dates out. August
Phrased it
9th
wrong, and
was
that's
I
what
think was the first asking of the date when the enforcement was asked. The permit expired on the 15th of July. The application was filed for renewal was filed on May 15. So the issue for me is as Mr. Johanning said, really is whether or not Mr. Prondak was within his discretion in, when he was informed, what was he supposed to do when he was in, what was his duties, I think was the phrase, when he was notified of the violation on the 9th.
Right.
Special permit language for, sorry, the language of, is it with section 3, paragraph N, for this particular special permit process is, I don't want to say ambiguous, but at least silent as to, on the issue as to whether or not the filing of the application is enough for renewal purposes, or whether, as long as it's in before the expiration. There are no cases, apparently, we'll find out in a moment, maybe or maybe not directly on point. So that leaves the, in my view, some discretion in the view, in the charge to the building commissioner to enforce the bylaw. We want to look at sections to enforce the bylaw. I would look at section 8, which talks about enforcement. It says the building commissioner shall enforce the provisions of this bylaw. Straightforward enough. If the building commissioner shall be informed or have reason to believe that any provision of this bylaw or any permit or decision thereunder has been, is being, or is about to be violated, he shall make or cause to be made an investigation of the facts, including the inspection of the premises where the violation may exist, and if he finds any violation, he shall give immediate notice in writing to the owner or his duly authorized agent and to the occupant of the premises. That's what the bylaw says is his duty for enforcement. So he was informed on August 9th that there was a potential violation. He made an investigation. He reviewed the terms of the bylaw with respect to the issuing of what the renewal process is. He found, I don't want to say vagueness, but at least some ambiguity as to what was precisely required to comply with the terms for having a renewal. He is charged, and we have, given him in the past when he has been before us, when a challenge has been made. Obviously, he's got some latitude in trying to implement the terms of a bylaw, a zoning bylaw, within the real world. And it seems to me that whereas I think Mr. Prondak's point is well taken in the sense that if this renewal had been filed a day or two before, or some period of time shorter than 60 days before the expiration, if it had been filed before or after, certainly after, I think, as he stated to us, he would feel very differently about the nature of whether or not a cease and desist order was appropriate. In my view, I think filing the renewal 60 days before is not unreasonable in the light of, I know the planning board is busy, but it's, 60 days. It's not 2 minutes, it's not a day, it's not a week, it's a significant amount of time. So this is a long way of saying that I think that I would support the building commissioner's actions in the steps that he took. He's required to make an investigation. Obviously, and that if he finds a violation, in other words, he has to give notice to the owner. There's, as Mrs. McKettrick points out, there's due process, there's notice and a hearing. You don't just cut off rights without due process. And so I think that part of that due process is this hearing, which is being held. It so happens that the special permit for the operation of the landscaping business was issued, in September, whatever it was. I didn't write it down, but prior to this hearing. So, in my rather long-winded explanation, I would tend to vote in support of Mr. Prondak on this issue because I believe that the steps that he's took in response to the complaint from Mr. Johanning were reasonable in light of the ambiguity in the bylaw as to what constitutes exactly compliance with the renewal provision. And that that's pretty much what I would say. All right, leave it at that.
Okay. Well, thank you very much. I have taken a look at the law in this particular instance, and to be frank, I think it's pretty well decided and well acknowledged in this Commonwealth of Massachusetts. You have to look at I start out looking at the 48 Section 10, which deals with variances. Now, this is not a variance, I'll give you that. But with respect to variances, it says that the permit granting authority can extend the time for exercise of such rights for a period not to exceed 6 months, and provided further that provided that the extension is filed with the permit granting authority prior to the expiration of the 1-year period, okay? So here, the application was filed by Mrs. McGettrick in May, seeking a renewal of the special permit. Now, the scholars who know more about the law than I do, Mass Real Estate Manual, Mass Real Estate Practice and Systems, they say that these provisions with respect to extensions of variances are equally applied by the courts with respect to special permits, okay? And they cite the classic case of Bernstein versus Falmouth. It's 52 Mass Appeals Court, 422. Huntner versus Cape Cod Condominiums, 52 Mass, 429. So I think it's fairly well decided in Massachusetts that for a special permit to be extended, all you have to do is file, and it's wonderful Marion filed in May. That gave the planning board an opportunity to spend more time on it. But I actually think they could have gone right up to the day before the special permit, filed the application, and that forestalls, that's the magic word, that forestalls the expiration of the special permit. And I actually found a case that's in Vermont. Now, nobody's going to cite the Vermont law here in Massachusetts, but that's exactly, it's right on point. It's in Ray Chaplin's parking, wetlands, a conditional use determination, and where they say that by filing the request for extension, that forestalls the expiration while the hearings are taking place. And I understand the hearings took longer than anyone thought. Maybe they did, maybe they didn't. But they were resolved in September, being September 13th, I think I said. So
Yeah.
here, in my view, under Massachusetts law, that's, I think, is well decided. I don't think there's any issue in here. That once that was filed, the date of the expiration was extended, not from May for 6 months, but from July, whenever that date in July was. It was to expire for the 6 month period of time. There were hearings before the planning board. I have the minutes. We have the minutes here in evidence. Everyone attended the meeting. It looked like the meetings were vigorously conducted, as I guess these issues always are. Nobody in the minutes ever suggested that the special permit had lapsed or expired. And the planning board, in due course, issued a new amended special permit. But then I understand that Mr. Johannan may not agree with this. But what they did is they took the old special permit, they renewed it, and they amended it in certain ways that deal with specific instances that they were having questions about the operation of the landscaping business. And so then, therefore, in my view, Mr. Prondak, while he may be 100% right on customary practice and what's fair and all of this, in my view, from the cases that I've read, and I have not read one case that says if you file before the special permit ends, you don't get an extension. I think it's well established under Massachusetts law. And in fact, I found a case dealing with equitable tolling here, in the instance where the holder of a special permit really couldn't exercise the special permit because there were circumstances beyond his control. And the Supreme Judicial Court, let me just check this, Supreme Judicial Court of Massachusetts held that while you're supposed to exercise, and this is a variance, within a 1 year period of time, if there are circumstances beyond your control that prevents you from doing that, the time limit is equitably tolled. And so if they had gone beyond 6 months, I think they may be in a situation of equitable tolling, but they didn't. They stayed within the 6 month period. I think The filing was effective to keep the special permit in effect. Therefore, I think Mr. Prondak was correct in not issuing a cease and desist order. And that's my view of this. So I guess the question is, do we have any votes here to challenge Mr. Prondak's decision not to issue a special permit, to hold that he erred in not issuing a special permit, in not issuing a cease and desist order, as Mr. Joe Henning did, and there's no doubt that he did, in August.
Can you restate the question again?
Well, I'm
'Cause
gonna,
he-
well, I may have misrestated, I
Yeah,
may have missed
I
it.
just wanted to-
The point is, Mr. Joe Henning is saying the special permit expired when he asked Mr. Prondak. It was expired on August 9th when he asked Mr. Prondak to issue a cease and desist order, and Mr. Prondak failed to do that, or refused to do that. And the question, and this is an appeal by Mr. Joe Henning of Mr. Prondak's refusal to grant a cease and desist order on August 9th, or on several other occasions after that, where you made a similar request. And so my suggestion is that we find that Mr. Prondak did not err in refusing to issue a cease and desist order, and that his ruling was in accordance with Massachusetts law.
I agree with
I agree with you.
Okay, well, there we are. I'm sorry, Mr. Joe Henning, we don't agree with you.
No, I'm glad to know.
But thank you for coming tonight, and we'll crank out a decision, and be sure you get a copy of it as quickly as we can. Thank you, Mr. Prondak.